In Colorado divorce cases, parenting time is determined using a best interest of the child test or standard. The presumption in all cases, barring evidence to the contrary, is that it is in the best interest of the child for the child to be able to have the maximum amount of parenting time with each parent, which often results in a fairly equal, or what some people call a 50-50 parenting time schedule. Part of the parenting equation is also the ability for each parent to make positive decisions for the child. Now, once we get past this sort of nebulous best interest of the child standard, the court will look to various other things like the ability of the parent to be around, the ability of the parent to promote a positive relationship with the other parent, the ability of the parent to set the child's needs ahead of their own, and other such factors in determining really when it is in the best interest of the child to spend time with each parent. But the basic standard is the best interest of the child with a presumption towards maximum time for both parents. One of the most time-consuming parts of establishing a parenting schedule in a Colorado parenting time case revolves around holidays, weekends, vacations. To the extent that the parties can agree or work hard on agreeing, they can save the court and themselves a lot of time and save themselves a lot of money in having lawyers and other professionals try to figure this out for them. Each parent, each family has unique holiday traditions, has different summer or other vacation schedules, and there is no way to have a state standard for what those things should be. So agreement is very often the best. Barring that, courts will often award basically one for you, one for me, kind of parenting time during holidays. And the same thing with vacations. Just 1 year, parent A gets to choose their 2 weeks of vacation first, and the next year, and then the parent B gets to choose second, and the next year we reverse the roles with specific dates by which time they have to make decisions and stuff like that. But this is certainly a circumstance where even if the parents can't agree up front about parenting time being equal, once the court's made that decision, whether it is or isn't, to then work together to set the schedule, because otherwise what you're doing is you're handing it off to a judge who doesn't know you, who doesn't know the children, and the judge will make a generic schedule that you will then be stuck with and will probably disadvantage both sides roughly equally. People often come to us either because the other parent has violated the parenting time schedule or because they are being accused of violating the parenting time schedule. And there are ways that a parent can seek the help of the court to force the other parent to abide by the parenting time schedule. There are motions to enforce, there are motions for contempt, and other things that can be done to enforce the previously decided parenting time schedule. The most important thing to be able to do is to A, make sure that you've been abiding by it if you're the one who is trying to enforce, or B, that if you have transgressed the written schedule, that there was a really good reason and that you're able to articulate it, and that maybe you are suggesting a change so that this reason doesn't come up again. But if the parenting time schedule has been violated, the courts do have mechanisms that you can use a lawyer or use yourself to seek redress as to having that schedule put back in place. This question comes up a lot about whether a parent can be denied visitation or parenting time if they have not paid child support. And the easiest way to answer that is to, again, focus on the perspective that the court will have on this. And the perspective is that parenting time is a right of the child to have a maximum amount of time with each of the child's parents. So no, if the fact that that parent failed to pay child support should not and would not affect that child's right to have time with that parent. But there are other mechanisms to enforce the payment of child support that the parent who hasn't been paid can use. But denying parenting time is not one of them. There are many mechanisms for the court to help when there is a parenting time dispute between parents. Honestly, the most effective way is to not involve the court at all. If there's a parenting time dispute, to resolve it through direct negotiation, to have a mechanism in your parenting time agreement for mediation prior to going to court. But if we resort to the courts, the parents can ask the courts. There's actually a motion to clarify parenting time, or a motion to enforce parenting time. A motion regarding, there's even one just called motion regarding parenting time disputes. Depending on the level of severity and the level of sanctions one is looking for, one could choose one of those types of actions and seek the court to clarify or to enforce the parenting time, and to make sure that each parent understands what their rights, or the child's rights and responsibilities are regarding the parenting time.